Hi, I'm Shan Wu with a Under Color of Law take on possibly the first real test of enforcement of a TRO against the Trump regime. A federal judge in Rhode Island is now doubling down, as we'll put up in the headline here, on his order to block the executive branch's federal funding freeze. It's the chief judge of the Rhode Island Federal District Court, McConnell, no relation. He's telling the Trump DOJ that they are violating the terms of his TRO. His TRO, a temporary restraining order, was imposed last week, and it ordered the Trump administration to unfreeze any federal funding. That was a case which was brought by 23 state attorney generals, including the Rhode Island one, and that's why we're with the Rhode Island federal court. We've talked about this before, but I think we're going to increasingly see that it is the state attorney generals, the states, that are going to be leading the fight against these illegalities by the Trump regime. Interesting historical note, right? During the earlier era in the U.S., particularly during the civil rights time, it was more the federal government which was championing these individual civil rights and the rule of law against the sort of post-Civil War notions of the states, and particularly in the South. We're going to see a reversal of that now. It's really in these state attorney general offices we're going to have to look for that leadership. So let's review for a moment what that first TRO was, which was only last week. In that case, the 23 states were arguing that the Office of Management and Budget, OMB, which we'll be hearing a lot about that acronym OMB, which is part of the executive branch, they violated the APA, the Administrative Procedures Act, because Congress gave them no authority to stop federal funding. Count two was that they were OMB was acting in an arbitrary and capricious manner. That's, again, a standard within the Administrative Procedures Act. So we might want to just stop for a moment to go over some basic definitions of what is the APA. It's a law that was enacted in 1946 that governs how federal agencies can make and enforce regulations. It was promulgated back then because it was a period of time in history where there had been an enormous increase in the number of powerful federal agencies, and that was mostly during the Franklin D. Roosevelt administration, who created all these new agencies to implement the New Deal. So the APA was a way of trying to impose some order on that and to rein in the power of those agencies. The arbitrary and capricious standard is put in there, and as the name suggests, it gives pretty wide discretion to what the agencies can do, but it says you can't be just whimsical about it. That's the arbitrary and capricious standard, so that's a good example of it. And we're going to be hearing a lot of use of the APAs, as well as, we've been saying, our friend the TROs. So 2 counts in that original seeking of the temporary restraining order under violations of the Administrative Procedures Act. Then also several counts with regard to the constitutionality of OMB's actions. First, saying that it violates the separation of powers because Congress already allocated the money, and then specifically in the Constitution that this type of ultra-virus abuse of discretion violates the spending clause and violates the presentment clause as well. These are all the constitutional arguments. So one thing to think about here is, first, let's go back to the TRO just for a second, just to make sure we've got the foundation here. As the judge laid out, the legal standard for TRO mirrors that of a preliminary injunction we've all heard of. And in order to make the TRO, which would freeze everything in place, the court has to consider 4 factors: the likelihood of success on the merits, potential for irreparable injury, balance of the relevant equities, and the effect on the public interest if the court grants or denies the TRO. And when he analyzed that, that's what he found. The 2 elements you hear the most about tend to be likelihood of success as well as the harm aspect, because the likelihood of success is really important, because before a court is going to say freeze everything, you can't continue down on this path, it wants to make sure that there's some merit to the arguments. It's not just something made up out of whole cloth that's not going anyplace. So that's why they analyze that very carefully. And then the harm aspect is what makes the freeze necessary to do. So let's take a look at how the judge analyzed the likelihood of success. It can be summarized as the judge really taking apart the Trump regime's arguments that it's really presidential whim that controls. The executive's wish to make its policies controls everything else, including the constitutional separation of powers. And the judge quoted Trump's argument, quote, to align federal spending and action with the will of the American people as expressed through presidential priorities. The judge points out that's really not the way it works and says the executive branch has a duty to align federal spending and action with the will of the people as expressed through congressional appropriations, not through, quote, presidential priorities, quote marks of the judges. That really goes to the heart of this, right? That's what the Trump regime, in this effort to expand the executive power to the point where it's really just a dictatorial system, is going to just keep pushing. That they have the ability to change everything to align it with policies. You're going to see that theme come up over and over again, and the pushback's going to be, no, you have the power to make policies. You don't have the power to take laws that have already been implemented, change them because you have different policies. You'll need to have new laws for that. And the APA carves out areas where the agencies can administer particular policies, how they're doing things, but it's not going to be at this wholesale purging level that the Trump regime is trying to do. And their first step there, right, is we're going to stop all the payments. Can't use any of that money till we figure out how to change the structures, till we figure out how to take away these programs that have been already mandated, that have been put into law. That gets us into the irreparable harm. So the state AGs detailed many examples of the kind of harm that happens, and it's so broad. I mean, highway planning, construction, child care, veteran nursing care funding, special education grants, state health departments who receive billions of dollars to maintain their health systems, drug enforcement, disaster relief. And the judge also makes the point that in addition to all of this, liberty is always at stake. So this judge clearly gets the big picture. Turning to the equities, kind of an interesting argument. With the equities, the court has to balance the harm to both sides. So here, the judge balances what's the harm to the states versus the harm to the executive branch. So if you look at that, there is not much harm to the executive branch. I mean, there's all this terrible harm being done to the states and the people of the states, as opposed to what happens if you do a freeze here. All that happens is the executive branch has to do what originally they were going to do, which is to distribute the money as Congress directed them to distribute the money. Put another way, doing your job shouldn't be considered irreparable harm to you. Now, it was interesting because the DOJ tried to argue that all this is moot, too, because they rescinded one of the executive orders saying that the funding, all federal assistance was going to be frozen. But at the same time, the new White House press secretary was making contradictory statements saying, yeah, that memo's been receded, but there's still a funding pause. It's just a complete ball of confusion. But the judge cut through that to say, whatever they're saying, this is still an issue that you cannot change the appropriation of the funds. Now, fast forward till now, not only was the judge cutting through that, but now the case was back before the chief judge because there was arguments from the states that DOJ was violating the TRO, that they were still holding up the funding. So the judge reviewed this and he concluded, I'll quote a bit from his order, quote, the states have presented evidence in this motion that the defendants in some cases have continued to improperly freeze federal funds and refused to resume disbursement of appropriated federal funds. The defendants now say they're just trying to root out fraud, but the freeze in effect now were a result of the broad categorical order, not a specific finding of federal fraud. So there, the judge kind of sees through this kind of new rationalization. Oh, we're not really freezing anything. We're just trying to root out fraud, something they really have not pursued before. It's just their latest idea of how can they justify their refusal to comply with the TRO. The court also says, my TRO was very clear, you're in violation of it, and the defendants had previously acknowledged that they understood what the TRO required, which was that federal agencies cannot pause, freeze, impede, block, cancel, or terminate any awards or obligations on the basis of any OMB memo. So it's very clear now, and the court disagrees with the defendants claiming, oh, TRO wasn't clear. The court says it's absolutely clear. You're violating it. Fix it. Now comes the test, right? How to enforce it? Well, they have to enforce it. You see Vice President J.D. Vance already openly questioning the judicial authority for the country. And as has been reported, he said that judges, this is a quote, judges aren't allowed to control the executive's legitimate power, delivering a warning shot to the federal judiciary. Now, notice his crafting of that. I mean, whatever we think about Vance, I guess he did go to law school and graduate. He emphasizes, or we should emphasize, the executive's legitimate power, right? So you're going to see a lot of commentators saying how the president does have certain authority. The emphasis is going to be on the word legitimate and how even courts can't change that authority. That's the whole question, though, isn't it? The courts have to determine if it's legitimate or not. So we're not going to be fooled by that nonsense, throwing in that little disclaimer there. Of course, the courts can control the executive's power when it is in excess, it's an abuse, when it's illegitimate. That's exactly what's before the courts right now. Now, to the extent that he is saying, J.D. Vance is saying, that they're just not going to obey the courts, that really gets us to the enforcement question. How's it going to be enforced? Because, the courts don't have a military, they don't have a police force. And the lower echelon people in the agencies may look to comply with court orders. They aren't in the habit of just blowing them off. But if they're ordered not to comply, or if they're fired or placed on administrative leave, the situation escalates. There's been a lot of talk about how that would bring on a constitutional crisis, and a lot of people are saying that we're already in that constitutional crisis. But really, the label doesn't mean anything. What matters is what's going to happen, whatever we call it, and the faster we learn what's going to happen, the better it is. So that's it for now. Good to talk to you. We'll keep an eye on this as well as all the others. Do follow me on Blue Sky for more up-to-the-minute updates. There's so much breaking all the time right now, and love to hear your suggestions and feedback about what to cover a little bit more in depth here. Talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.